Well, it is a little bit after 1:30, and we will go ahead and get started. And for everyone's awareness, this is being recorded and will be broadcast later. But for anyone who I don't know, I'm Frank Williams, and I'm the Brunswick County Commissioner and past president of the Association of County Commissioners. As you know, yesterday was Constitution Day, which is a day set aside to reflect on the signing of the United States Constitution, which is one of two constitutions that deal with what county commissioners do in North Carolina. The other one is the North Carolina State Constitution. And we have with us today Chief Justice Paul Newby of the North Carolina Supreme Court, who I met, I think, before he was even an associate justice. I think on your first campaign is when we met. What year was that?
2004.
2004. He has one of the two most famous campaign slogans in North Carolina history, which is Scooby Dooby, vote for Newby, that his daughter came up with many years ago. And she's gone from being the little girl who came up with that slogan to a working professional who raises money for the Republican Party now. And it's amazing how much time has passed during that time. But I'm going to go ahead and turn it over to Chief Justice Newby and let him just give us thoughts on the U.S. Constitution, the state constitution, how they relate together. Then we'll have questions after he finishes. If you have questions, you can go ahead and put them in the chat or use the Q&A feature. But with that, Chief Justice Newby, the floor is yours.
Thank you. First, let me applaud Frank and his civic awareness, recognizing the importance of ensuring that our citizens are well aware of our various constitutions. Frank, thank you for doing that. And since 1776, our state constitution, state constitution has reminded us that a frequent recurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty. And that's really what we're going to be touching on today. The foundational principles that are present that preserve the blessings of liberty. In the run-up to our Constitutional Convention, we had the Articles of Confederation that required unanimity among the 13 states in order for things to be done. And it was evident to George Washington and others about how important it was, particularly for national defense, but also commerce between and among the states, these types of things, that there needed to be more of a central government. The convention began in the late spring, early summer of 1787. There were various delegates from most of the states. The only state that did not have those that attended was actually Rhode Island. But the idea was, can we, as these 12 states, can we craft together some compromise as a general understanding of the foundational principles of our government? Let me start by saying, while I've got two constitutions here, federal and state, we also have had prior constitutions. Actually, North Carolina, being one of the two Carolinas, was part of the Charter of Carolina that King Charles II granted various of his supporters to be the Lord Proprietors. And they came up with a constitution called the Fundamental Constitutions of Carolina in 1669. It's said that John Locke actually participated in the drafting of that document. As we started our course of independence, keeping in mind that the top yellow ribbon on the state flag, May 20 of 1775, is the date of the Mecklenburg Declaration of Independence, the first declaration of independence of any group. I jokingly say Mecklenburg County declared its independence in 1775 and has maintained that independence fiercely since then. But as we got together to think about our state constitution, one of the first things we did was to develop a Declaration of Rights. Okay, Declaration of Rights is like the Bill of Rights, but it goes in front of, not behind the Constitution. And actually in 1776, it was a separate document. It reflected what would ultimately be captured in the Declaration of Independence, or had been captured, sorry, in the Declaration of Independence, that says we hold these truths to be self-evident, that all are created equal and endowed by our Creator with certain inalienable rights, life, liberty, pursuit of happiness, and the government exists to protect, not to grant, to protect these fundamental rights and freedoms. So when we got together in December of 1776 to approve our Declaration of Rights and our structure of government, which we call our Constitution, the first thing we did on December the 17th of 1776 was to pass our Declaration of Rights. It's a little bit more detailed, a little bit longer than what we would call the Bill of Rights. Basically, it addressed various concerns that our framers had, as had been experienced by the what they considered to be the tyranny of the British during that period of time. But after they adopted their Declaration of Rights, they went home, came back the next day to adopt the structure of government, recognizing God gives us rights. Our rights are above the government. The government exists to protect fundamental rights and freedoms. The state constitution is a very different type of constitution than the federal constitution. So the state constitution is a limitation on power. What that means is that it says in our state constitution that all political power resides in we the people. How do we exercise that political power? We're not a democracy. We're a representative republic. How do we exercise that? We elect our representatives to our state house and senate, and they act in our stead, on our behalf. And they're prohibited only from doing those things that are expressly prohibited in this written document. The concept is, if you prohibit the General Assembly from acting, you are in effect prohibiting we the people from acting. So our standard of proof that the North Carolina Supreme Court has historically applied is there's a presumption of constitutionality of every act of the General Assembly, and that the proof has to be a violation beyond a reasonable doubt. The best case that explains that is a case called Baird versus Singleton, which is found in the North Carolina Reporters 1 NC5. It dates from 1787. And in that case, the General Assembly was concerned about some of the folks who had lost their property because they refused to take an oath of allegiance to the state during the Revolutionary War. And they passed a law that said that there would be no jury trial under those circumstances. Well, the problem with that is the Constitution said you have a right to a jury trial under those circumstances. So 3 of the judges, and the judges were appointed by the General Assembly, as was the governor and every other office in the state. Why was it like that? Well, study history and Lord Tryon and his tyrannical power that he exercised, which caused the framers to very much limit the power of the executive branch. So ultimately, these 3 judges who served at the pleasure of the General Assembly said, General Assembly, you can't pass a law that violates the fundamental foundational document, our state constitution. And it's clear beyond a reasonable doubt that you've done that, because the Constitution guarantees the right to a jury trial under these circumstances. So that's the kind of proof there. That North Carolina's Constitution was one of 13 that these group of people in 1787 had as they sat down to draft a federal constitution. The big challenge with the federal constitution was you had states that didn't have very many people, and North Carolina, frankly, was one of those. We were late to be settled and had few people there. Now, there were some newbies there in North Carolina. The newbies made it over in 1680. They were run out of Virginia because they were Quakers and settled in Perquimans area. But we didn't have a lot of folks. It was hard to settle North Carolina, and a lot of our settlement came south from Pennsylvania or Virginia and north from Georgia or South Carolina. It was hard to go from east to west, as in the other states. The settlements came from north or south. So we didn't have a lot of people. A lot of the states didn't have all that many people. And they said, if we form a federal government based on population, we're going to get overlooked. Whereas the populous states said, well, that's the only way that it makes sense. That was called the Virginia Plan. Let's do it based on population. I think it was the New Jersey Plan was, well, let's do it equal representation for every state. Make it more or less like, instead of the Constitution beginning "we the people," it could begin "we the states." It seemed to have gotten to a place that they couldn't figure out where to go next until there was a compromise. And the compromise was the House of Representatives would be by population, and the Senate would be based on equal representation among the states in the Senate. Once they got that structure in place, then it seemed like the other aspects would ultimately fall into place as well, and did. We had 3 delegates. North Carolina had 3 delegates who ultimately signed the Constitution. You had Blunt, and you had Williamson, Dr. Williamson. And Dr. Williamson really participated more than Sprate and Blunt, Sprate being the other one. Dr. Williamson articulated well his concern about a powerful executive branch, concerned with the English model in Lord Tryon. He proposed and debated that the president, one of two approaches. One would be that there would not be one president, but there would be 3 to divide that executive power. Very much like in North Carolina, although we have a governor, we have a multi-headed executive branch, and the governor leads the executive branch, but you got the Commissioner of Agriculture, the Secretary of State, the Attorney General. You got all these constitutional officers who have their own duty to the state. Dr. Williamson, medical doctor, said, if we're not going to have 3 executives in that role, then let's limit the term. Let's make it a 1-term, 7 years. No running for re-election. Those ideas were debated and ultimately, as we know, not adopted. So on September the 17th of 1787, the doors were finally open. Prior to that, the windows were shut, the doors were shut. The delegates had been instructed they could not talk about anything that occurred during the convention itself. But fortunately for us, although prohibited, James Madison did take notes. So we do have some pretty good ideas about some of the debates, some of the things that went on. And the doors finally opened September the 17th. This document is presented as the proposed Constitution to be presented to individuals who are elected in each of the 13 states for the specific purpose of debating ratification of the Constitution. The oldest delegate, Benjamin Franklin, comes out of the meeting, and some ladies from Philadelphia say, Mr. Franklin, what kind of government have you given us? And his response, which rings true today, is it's a republic if you can keep it. And that's really, I think, one of the motivating ideas of Commissioner Williams is it's a republic if we can keep it. And part of our keeping it is understanding the various checks and balances, understanding its function. So the federal constitution, unlike a state constitution, the federal constitution is not a limitation on power. It's a limited grant of power. In other words, at one point I was an assistant United States attorney, and the first question that occurred in every case was, what gives the federal government jurisdiction under these circumstances? Why is this in federal court as opposed to our general courts of justice, which have to do with our state courts? And the same thing is true with the federal government. What in the Constitution, the federal Constitution grants the federal government the power here? Because all power not expressly reserved for the federal government is reserved for the people, for the states. So the difference with this Constitution is it is a limited grant of power in theory. Just in general, what are the purposes? It says it very clearly in the preamble, to form a more perfect union, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Our state constitution has a similar preamble. It says, we, the people of the state of North Carolina, are grateful to Almighty God, the sovereign ruler of nations, for the preservation of the American Union in the existence of our civil, political, and religious liberties, and acknowledge our dependence upon him for the continuation of those blessings to us and to our posterity. The big debate centered around the ultimate power of the federal government and protection of fundamental rights and freedoms. In this book, which I highly recommend, the Federalist Papers, Madison, Hamilton, and future Chief Justice of the Supreme Court, John Jay, argued that a Bill of Rights was unnecessary because the ultimate power of the federal government would not be so broad as to intrude on the fundamental rights and freedoms of individual citizens. North Carolina politely said, we don't believe it. Baloney. Power corrupts, absolute power corrupts absolutely. We want protection of our fundamental rights and freedoms. There was our state, the other side of this is the anti-federalist, and I also recommend this reading, the Anti-Federalist Papers. And it talks about the dangers of a powerful centralized government. Ultimately, North Carolina is the only state to have not ratified the Constitution at the Constitutional Convention that it first held. It was in Hillsborough on July the 21st, 1788, and basically the ratification was voted down. We're not joining until there's a Bill of Rights. Ultimately, the folks in Washington got the news. They understood, and Washington prevailed upon Madison draft a Bill of Rights. That Bill of Rights was proposed in the fall of 1789. North Carolina held its second constitutional convention in Fayetteville, where they ratified the Constitution and ratified the first proposed amendments to the Constitution. Now, there were 14 original copies of the Bill of Rights, one for the federal government, one for the 11 states that had ratified, and one for North Carolina, who voted it down, and one for Rhode Island that, again, they were kind of missing in action. Upon receiving our original copy, we voted to become a state, becoming the 12th state of the Union. Some of y'all have heard the story, but in 1865, a Union soldier stole North Carolina's original copy of the Bill of Rights. In 2003, I was an assistant United States attorney that got it back. And as I jokingly say, National Treasure 3 coming to a theater near you. That's another story for another day. So when we think about these two documents and we think about the theory of our state constitution and our federal constitution, understanding they're being very different in nature helps us then interpret those documents or apply those documents. However, I would be quick to say that both documents have provisions for amendments and the proper way to get those amendments, none of which anticipated judicial revision of those documents. That's why, in my opinion, it's important for us to have justices that will be faithful to the text of our state and federal constitutions. And that way, if folks decide they don't like what the text says, they don't like our original agreement, they can properly go through the amendment process. I compare it to somebody who decided to build a house and they entered into a contract for the house to be built for $250,000. And ultimately, they get a bill for $500,000, and they're like, well, look at the contract, and the builder says, yeah, but my prices went up, my labor went up, my material went up, everything went up. And the buyer's like, if we were going to modify our contract, why didn't we modify it? How can you now come in and try to impose these terms on me? So that's same thing. What do we expect? We expect courts to properly apply these documents and apply based on the original intent, which was the foundation of the social agreement. And just to be clear, a constitution is simply a social contract, but it's a foundational social contract. And the principles that we use to interpret and apply contracts certainly should be applied to these as well. Frank, I think that's it in terms of my initial presentation. If there are some questions, I'm glad to try to answer them, but let me go ahead and preempt. If you ask a question that about an issue that is pending or could be pending before the Supreme Court, I am not able to answer that question because I have to speak through my opinions, and parties have to appreciate that I am not prejudging a particular issue.
Thank you, Chief Justice. And I think that was, you covered a lot in a short amount of time there. And one of my takeaways, and I had never thought about it this way, is and correct me if I wrote this down wrong, but what I took away is the U.S. Constitution is a limited grant of power, and the state constitution is a limitation of the legislature's powers. Is that accurate?
Spot on.
Okay.
You would get an A in my Constitution class.
I just, that I'd never heard it articulated quite that way. And I think that is a fundamental difference in the two that I think we need to be aware of. And I've actually posted a link to the Declaration of Rights from the state constitution in the chat earlier for anyone who wants to review that. We do have one question from Vince Musilli. And hopefully this won't violate the clause you just threw out about a future case, but I'll throw it out anyway. What is the downside or penalty for local DAs bringing spurious charges against President Trump and others? Legal fees, court fees, etc.
Well, sadly, that does. Under my code of ethics, I can't comment on pending cases in either the state or federal court system. What I often find so frustrating to we the people is we see things going on in our judicial system and wonder how we can address those wrongs. And there are ways, but it takes a while. The case is over, so I can comment this way. You look at the Duke Lacrosse case, and you have great sympathy for the Duke lacrosse players that, as it turned out, were not just wrongly accused, but what was it? A good number of professors at Duke filed some petition to cancel the season, and many of these young men were, for better or for worse, had to leave school. And yet ultimately it was determined that the witness was not being truthful. And so it just takes a while. The process, okay, I get justice delayed is justice denied, and our state constitution says the courts will be open and justice will be administered without favor, denial, or delay. But ultimately, the process has to work, not just the trial, but the appellate process as the law becomes clarified through the appellate process.
Thank you. We have a political question, but I think it's one you can answer from Justin Lovin. He wants to know what advice you would give someone about getting into politics.
Find somebody else to do it.
I somehow knew you were going to say that.
Yeah. You know, my advice is be reluctant. That sounds strange. I mean, once you're in, you got to be all in, and you got to have fire and get out and do all the things. You got to outwork everybody.
Yeah.
But be sure you are being called to that. Okay. I'm a person of faith. I believe that God has callings on people's lives. Okay. And I also believe that just because you're called to run doesn't mean you're going to win. Okay. I've had way too many friends not ultimately win. But I do think that, you know, it troubles me to see as many primaries as we often have when people who have similar worldviews and would be similar positions on issues. And certainly one of the questions I asked myself in 2004 is, was there someone else who would step up with the judicial philosophy that I had? I believed in judicial modesty, judicial self-restraint. I mean, you read my opinions since 2004 and all the dissenting opinions I've had to issue. I think I've been faithful to my judicial philosophy. And so, you know, I work with a lot of young people who say, hey, I want to run for this or I want to run for that. My counsel is don't run until somebody else says, wow, you're really gifted in this, other than your parents. Okay, I got that. But you're really gifted in this, and this is something for the community, for the sake of the community, you should consider. So, you know, probably not the answer you wanted to hear, but on the other hand, service, public service, there's nothing more important. And frankly, don't overlook local elections. I get so many folks who say, I want to run for Congress. It's like, why? Don't you want to make a difference? I mean, be a county commissioner, be a school board member, be a city councilman. Don't overlook the local positions, because you can truly have a great impact, or greater impact on your quality of life in your community in local government than you can elsewhere.
And they responded and said, great answers. Thank you. And I'll throw in a few answers on that. I think number one is, you know, get into it reluctantly. Make sure you know what you're getting into. Understand the job you are running for. I think that's a mistake I see people make, is they run for a job not having any idea what the job actually does. And that can especially happen at the local level. Understand what issues you might be faced with. And you know, if you're running for town council, you may get asked about federal issues. And if you get asked, you probably shouldn't shy away from them. But don't make a federal issue that you cannot impact the centerpiece of your campaign. And also don't paint yourself into a corner by giving answers to questions you haven't researched, and put yourself in a position where you've made a promise that you cannot keep. I've seen, especially at the local level, people say, I would never do X, Y, or Z. And then they get elected and they find out it's a statutory requirement for their level of government to do X, Y, or Z. or they say, I will always do it, and they find out that the statutes do not allow them to do it. And that's a whole different soapbox. But the state, the county, local government in North Carolina is created by the state, and the county is specifically the administrative local arm of state government. And we are very much hemmed in by what the state statutes do and do not allow us to do. And I won't take any more of Justice Newby's time by getting on that soapbox, but that's something to be aware of. We have a question from
that's a great point, though. That's a great point that under our state constitution, it is the General Assembly that creates local government. And Frank, that just shows that you are a textualist as well as you're thinking about, okay, what specifically has the General Assembly authorized county government to do versus, hey, that's a great idea, but it's not in our statutory authorization.
And North Carolina is different than many other states in that regard, where they have more of a local home rule capability than we do here. And that's something that's, especially for many people in my county who move from another state, to understand that county government is different from state to state. And we've got a saying that if you've been to one county, you've been to one county. And I think that is absolutely true. We have a question from an anonymous attendee who says, when the federal government goes beyond the specific powers granted in the U.S. Constitution, what can the North Carolina government or courts do? And I know you probably can't answer that from an issue specific perspective, but maybe from a process perspective, you could touch on it.
Yeah, so that is litigated frequently in the federal courts with regard to did the state government, the federal government and a federal regulatory agency, did they go beyond what they are authorized to do by statute? So that issue certainly is frequently litigated, and a lot of times it's attorneys general that join into litigation. It's so important that we have an attorney general who is attuned to those kinds of issues when they see the federal government usurping roles that were reserved for the states, because the U.S. Supreme Court certainly is interested in what the various attorneys general across our state, across our nation, would have to say on the power of the federal government vis-a-vis the power of states.
And we've seen in North Carolina instances where if the legislature did not feel that the attorney general was doing that they've hired their own counsel and filed their own suit. So that's another thing that we've seen happen. Next question from Bill Hall. To what extent does the Bill of Rights have legal standing? I am interested in the right to life, liberty, etc. statement as being a definitive answer to the abortion issue, as it is so clearly stated in this foundational document.
So you're referring to the Declaration of Independence, which actually that language has been incorporated into our state constitution in Article 1, Section 1, which is the first of our Declaration of Rights. And we added to that everyone's entitled to the fruits of their own labor, which recognize the dignity of all work and the significance of being able to earn a living. So under our state constitution, those concepts are litigated. The federal constitution, it seems like that concept is not expressly inserted into the federal constitution. And of course, with regard to any specifics with regard to those rights, I can't comment on those. But as a general proposition, this court, particularly now, is beginning to see cases that have to do with businesses that are contesting some of the COVID restrictions that impacted their businesses, things like that. So those are issues that are being currently litigated.
And I'll ask one. Can you talk a little bit about one of what I think is one of the forgotten pieces of the Bill of Rights, which is the 10th Amendment, and what it says and how it should apply and that type of thing?
Yeah, so let me read the
free rein to say whatever you want about it.
Yeah, thanks. The 10th Amendment says the powers not delegated again, this is a delegation of powers. That's what this document is. Powers not delegated to the United States by this Constitution or the Constitution, nor prohibited by it to the states. In other words, the Constitution doesn't say the states can't do this, are reserved to the states respectively or to the people. So that's the idea, if you will, bundle of rights. Individuals take some of those rights and created state government. They took a few of those rights back from the states, took a few more of their bundle of rights, and they created the federal government. Okay, but basically, what the 10th Amendment says is, if the federal Constitution doesn't give it to the federal government, or it doesn't prohibit the states from exercising it, it belongs to the states. So very soon after this document was ratified, there was a dispute where the federal courts were deciding issues with regard to the role of states and this type of thing. And the 11th Amendment was ratified in 1795. So, not long after the Constitution itself, and the Bill of Rights was ratified, I guess, in 1790. Well, I've got it right here. Let's see when it was ratified. 1791. So 4 years later, they add this: the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So, in particular, though, the 10th Amendment is simply there recognizing the theory, the political theory, that the federal Constitution is simply a limited grant of power, and recognizing that the states were to continue to exercise a great deal of authority over the daily lives of its citizens.
Thank you. And I'll share a discussion that I had with someone that related to that. I had someone who said, I don't understand why counties build parks. There is nothing in the Constitution about building parks. And I said, well, it's in there. It's in the 10th Amendment. And they asked me what the 10th Amendment said, and I read it to them. And in North Carolina, the state gives counties and towns the ability and authority to build parks. So that's where our authority came from. And I think that's a distinction that is often confused. People think that if the U.S. Constitution doesn't directly allow a county or town to do something, that we can't do it, or vice versa, that type of thing, when it's really the state that defines specifically what counties can and cannot do. And obviously, there are U.S. constitutional provisions that apply. First Amendment certainly applies in a lot of things, but I think it's important to understand that delineation, and that the state constitution is what directly governs the day-to-day operations of counties and towns. Anything you'd add or correct on that?
Well, we certainly can see our mindsets have been somewhat shaped by the post-Roosevelt New Deal understanding of the breadth of federal government. It does seem like that we're starting to appreciate some of the limitations on federal government. But what you said is exactly right. And again, if this doesn't grant the federal government exclusive rights about something, then you go to the state constitution and you go to our state statutes, which set out clearly what the local counties, cities can do. And the way you've expressed it, Frank, is right.
I have another question from an anonymous attendee. Does North Carolina have equity or administrative courts?
Yes, we've got all of the above. So the idea of equity in our courts, or equity courts, came down from the English system where you had courts of law that had to do with acts of parliament, and then you had courts of equity that had to do, frankly, with church courts. So people would go to the church courts for their equitable, non-legal. A lot of times it had to do with the states. It had to do with aspects that were not specifically covered by statutes in the law. And so, particularly in the earlier history of our state, there was a distinction between courts of equity and courts of law. And, one of the major states that has continued with that practice is Delaware. Their business court is a court of equity. Generally, a court of equity, it's the judge making a decision and it's not a jury. So the concepts, the distinctions, if you will, continue on in some ways. But we have a unified court system, which what would have been done in days of old are generally done by either the clerk or the district court, sometimes by the superior court, as they make decisions about what types of actions are tried by a jury, what types of actions are tried by the judge. And in terms of administrative courts, we have Office of Administrative Hearings. So if you are disagreeing with the decision of an administrative agency, you can have that heard by the Office of Administrative Hearings. You have review of that by a superior court, which tends to generally review that with more of an appellate type approach as opposed to a trial court approach. Nonetheless, my point is, unified court system, ultimately, all those types of actions make their way through our trial system, our appellate system. So it's an interesting concept. It's very interesting historically, but from a practical standpoint, other than you get a jury trial, you don't get a jury trial, the legal procedures would be the same.
Thank you. And I hope that answers the question from whoever submitted that. We talked a little bit about how local government, our responsibilities are defined by the state constitution. What are some areas in the U.S. Constitution that do directly apply to state and local government in North Carolina or in the Bill of Rights? Can you point out a few things where we are directly impacted by what's said in that document more so than the state?
Well, certainly the Bill of Rights serves as a prohibition upon what things states can do. For example, both our state constitution and our federal constitution prohibit what are called general warrants, which means, if you're going to invade somebody's home to search for something, or you're going to arrest somebody, you can't do it based on a general warrant. There has to be a specific showing of probable cause. Okay, so in the criminal context, civil jury trials may, certainly under our state constitution, we have civil jury trials. If you're in federal court, depending on if they're trying a case that's arisen under the federal constitution or their federal statutes, or if they're trying a case under the state law. So, those types of things. Frank, it's hard to kind of give a generalized answer per se. To me, the way I look at it is, does it tend to involve interstate something? Because if so, chances are it's covered by the federal constitution. But or does it involve national security? Does it involve immigration, federal bankruptcy stuff? Those aspects are derived from the federal grant of power through the federal constitution. Otherwise, it's going to be in the state, the power of the state, unless it's expressly prohibited by a state constitution. That's kind of a general statement.
And that could probably be an entirely different 1 hour session if we dug into that.
Well, I think they offer law school classes that go on for whole semesters on that.
I thought about going to law school, but the whole school part deterred me. So I decided not to do that. We have time for one or two more questions if anybody wants to drop one in the chat. Let's see if I think you've answered. I had some questions and you answered a lot of them preemptively. What questions?
Let me
go ahead.
Go ahead.
I was going to ask what questions you get asked most frequently about Constitution that maybe we haven't talked about today.
Well, the most frequently asked question I get is, "Oh, you're a Supreme Court justice. Can you help me with my speeding ticket?" Generally, that's not a constitutional issue.
If their speeding ticket makes it to the Supreme Court, they've got bigger problems.
You know, Frank, I get back to Article 1, Section 35, a frequent recurrence to fundamental principles. And, you know, sadly, I don't think many folks are taught the difference between these two documents. And without that basic understanding, they want to take what they've learned about the federal Constitution and those principles and apply them to our state constitution. And, you know, you're starting off on the wrong foot already. So my takeaway is, my encouragement is that your listeners would be encouraged to read the federal Constitution, read the state Constitution, read the Federalist Papers, Anti-Federalist Papers. And I just happen to have a book here, one of my favorite authors, Paul Newby. You know, it's on our state Constitution. So there are resources available, and I encourage people to do that, because the more informed we are, the better we are equipped to understand and process the news that may be occurring in the legal realm and the political realm.
See, we have another question. It looks like this one may be more of a legislative question, but I think that we've spurred a thought. What can we do to have basic law classes offered in K through 12? I think the first thing is find someone who's qualified to teach them.
Yeah. Yep. I certainly agree. I have gone to schools all over the state. I have been to numerous presentations to civics teachers. And, you know, I've been doing that since 2004. And actually, I did it before that as an assistant U.S. attorney. I do think that, just like you, Frank, you've answered the call. You have said, okay, I'm going to provide some civic education opportunities. And, you know, I applaud you for that. And hopefully others will take the challenge, go to online classes or classes on the state and federal Constitution, and then go out and teach others. So thank you all. And thank you so much for allowing me to have this time with you.
And thank you for being with us. I know you've got a hard stop in a few minutes, so we greatly appreciate your time. If anyone else has any other questions, if you want to get them to me, I can certainly get them to Chief Justice Newby and try to get you an answer, assuming it's one that he can answer. A copy of this video will be posted on my website in the next few days for anyone who, you know, who should see this but wasn't able to tune in. And again, Chief Justice, thank you very much for your time and for being with us. And thank you to everyone who tuned in today. And everybody have a great afternoon.
Thanks.